The judgment delivered by Honorable Supreme Court is very important with regard to these condonation issues. As you know that an order of NCLT is passed, it has to be challenged within 45 days. Lot of judgments have come in these things. Nagaraj judgment is being cited repeatedly. And then the jurisprudence turned out to be up to 30 days there is no problem. Above 30 days and below 45 days, we have to give reasons for condonation delay. You have to file a condonation petition. And the courts have started taking different views. And in this particular case, it is a 43 days. But then NCLAT passed an 18-page order dismissing that. And the matter came to Supreme Court after counters, rejoinders, sub-rejoinders and all. The appeal came for the hearing yesterday. Yesterday means it is 6th of 11th of February. So the Honorable Supreme Court, of course, spoke for at length and passed an order. But what is the sum and substance is, NCLAT should not be guided by a hyper-technical approach. No doubt, IBC proceedings are time-bound in nature. Here what you achieved, first step is NCLT itself would have spent so much time. Counters, rejoinders, sub-rejoinders. Then it comes to NCLAT. Again the same thing, condonation of delay. And then finally Supreme Court, it is again another 1 year taken. So the purpose is defeated. Therefore, we have to take into consideration a liberal approach, taking into consideration the circumstances of the case.
NCLAT, which has high tendency, should devote so much of time and energy in writing an order running to 18 pages for considering the application for condonation of delay. It is no doubt true that the timelines are of extreme importance under IB code. But the result of taking hypertechnical view by NCLAT is that in view of the improved order, the entire proceedings are delayed for more than 1 year, as the appeal has remained pending in this court for more than 13 months. Full stop. Next paragraph. Instead of adopting hypertechnical approach,
today, Honorable Supreme Court passed a very good judgment on the condonation of delay. That is petition when judgment or order of NCLT, it has to be challenged before NCLAT within 45 days. Section 61. 30 days, then no problem. And the next 15 days, you need sufficient cause of action. Generally, in the initial stages, 45 days is taken and just some reason you give. Then slowly the judgments of Supreme Court, contradicting judgments, one bench or the other, they were insisting that you within 30 days, on the 30th day if you file, no problem. But suppose you are going to file on the 42nd day, let us say, that is above 30 and below 45 days. Then the question of interpretation, that is, you have to give reasons for the condonation. So you have to necessarily file a condonation delay petition, giving reasons. But during the initial stages, that was not at all considered as a big thing. It used to be allowed just like that. Justice Venugopal, benches and all, they were very liberal. Rightly so, because 45 days you have said, so within that 45 days it's okay. But then Supreme Court repeatedly passing orders, once they say this is okay, another says they say. And NCLAT also was, they have better knowledge about the ground realities. Then they used to interpret also. Now, what happens, we'll tell you, a case like this. The person, 30 days over, and he filed the appeal, 43rd day, 13 days delay, for which he gave some reasons. Honorable NCLAT benches, Justice Rakesh Kumar Jain sir is very kind, but he goes by a procedure. That first procedure is, if you are